convenes tomorrow morning at 10:30 a.m., they have a very tough question on a very delicate matter to answer. Whose right is supreme? A mother's right to choice or an unborn child's right to life? Let me explain, it's not complicated. A married woman, a mother of two, approached the Supreme Court asking for permission to terminate her pregnancy. She is 26 weeks pregnant, and Indian law does not permit abortion after 24 weeks unless there is grave danger to the mother or to the fetus. But the mother said she was not in a mental or physical state to carry the child. The government was not in favor of this abortion, saying that it would set a bad precedent and everyone will then come to court asking for exemption to the law. So the question before the Supreme Court was, are we pro-choice or pro-right to live? Choice of the mother and the right to live of the unborn child. A bench led by two lady judges, Justice Hema Kohli and Justice Nagaratna, ruled in favor of this 27-year-old woman and her right to choice. They said it's supreme. This happened on October 9th. But 2 days later, the court put their own order on pause. Why? Because the government came to them saying that an AIMS report on the health of the fetus has found that it had a heartbeat, which means that this is a strong, living fetus, that this is a baby, not just a fetus. This new dilemma made Justice Hema Kohli change her mind. She said, and I quote, "My judicial conscience does not permit me, for heaven's sake, which court will stop the fetal heartbeat?" But Justice Nagaratna stuck to her stand, and so the bench was split. The matter reached the Chief Justice of India. There was a controversy there, but that is a story for another time. Today, the Chief Justice of India dropped everything he was doing and heard the matter on priority along with two other judges. He was told that the mother appeared suicidal and was going through something called postpartum infertility. She simply didn't want to keep the child. She was incapable of keeping the child. The Chief Justice of India's observations were strong, and his question was one that is not easy to answer, legally or morally. He said, and I quote, "The autonomy of a mother triumphs. But can a child be put to death under a judicial order?" Now, the Supreme Court will decide on that question first thing tomorrow morning. And when it does, it will be a landmark order. Before we debate if the right to choice is supreme or the right to life, let us tell you what the abortion law in India is. And let me tell you, they are very liberal by all accounts. The Medical Termination of Pregnancy Act 2021 allows abortions up to 20 weeks of pregnancy, only requiring the medical advice of a doctor, which means abortion is absolutely legal up to 20 weeks. You don't need any permissions. But in certain circumstances, permission to terminate pregnancy up to 24 weeks is also allowed. If a woman is a rape survivor or differently abled, she can be given permission to abort the child after due consideration from a state medical board. In fact, this has happened. This happened yesterday as well, when the Mumbai High Court allowed the termination of pregnancy, and the woman was 29 weeks old pregnant because she was mentally unstable and she had been raped. So even at 29 weeks, there are courts in this country that have allowed termination of pregnancy. And let me tell you that all these rules apply to unmarried women and minor girls as well. Minor girls, provided there is consent of a guardian. Now, in extraordinary cases, women who are above 24-week pregnant can go for abortion, as we saw in the case of a 25-year-old. The Bombay High Court on October 9th allowed medical termination of a 29-week pregnant woman who is a sexual assault survivor and is also physically and intellectually challenged. Based on the medical panel's report, which said that women can incur grave injuries to her mental health if the pregnancy is allowed to continue, the Bombay High Court bench deemed it appropriate for the petitioner to terminate her pregnancy. As I said, the abortion law in India is very progressive when we compare it to the so-called developed and liberal democracies, say like the United States of America. In 2022, the Supreme Court of the United States overturned the right to abortion, which had been providing women their constitutional right since 50 years. That's America, ladies and gentlemen. Over a year has passed, and till date, termination of pregnancy is banned in some form or the other in over 20 US states. But as I said, this particular case has posed a dilemma, a moral and a legal dilemma in front of India's top court, the Supreme Court. Talish Ray is an advocate. She's joining us on the broadcast. Sunita Ojha is an advocate of the Supreme Court. And Anvesh Madhukar is a lawyer. Ladies and gentlemen, thank you very much for your time. Sunita, I want to ask you where you stand on this very delicate and sensitive debate. Because there are points and there are counterpoints. And, you know, there is logic that both sides give, which you can't help but agree to.
So I will confine my opening remarks to what is the legal recourse that is available. Like you have said repeatedly, that about laws allowing a woman to abort her pregnancy are fairly legal and fairly liberal as far as the Indian women are concerned. So till 20 weeks, no question asked. Till 24 weeks, also very, very liberal. Right, the way it was interpreted. In fact, the the Chief Justice now last year, in fact, gave the same rights to unmarried women also. So in and as far as the pregnancy, the length of the pregnancy is concerned, that question has been actually removed completely in case when there is a fetal abnormalities. So 20 weeks. No question, 24 weeks, 2 legal practitioners, and beyond 24, with unlimited time. It does not say that the fetus can be aborted in case there is a fetal abnormalities. I have looked at the judgments from Kolkata High Court, Bombay High Court, Delhi High Court, where the pregnancy at a very advanced stage, such as 30 weeks, 29 weeks, 33 weeks, the courts have given permission. Now, in the present case, the dilemma is slightly different because here the first woman approached after 24 weeks. That is, she is 26 weeks pregnant. So, you know, she goes out from 20 to 24. Now she is in 26 realm. So at this stage, what becomes important is the opinion of the medical board. So here medical board comes to the court, gives an opinion saying that the fetus is of 860 grams. They will have to do a proper delivery to take the child out, unless the Supreme Court gives us the right to do what is called the foeticide. That's where the court, the proceedings in the court became extremely what is called emotional, because court was also taken aback to say that, how can you ask us to give a permission? You are basically asking us to give a question was put to the woman also, the concerned woman, saying, is that what she wants? She wants a permission to commit foeticide. And on that, the lawyer turned around and said, no, she does not want. She just wants a delivery. And then the child can be taken care in the hospital in a neonatal unit. At this stage, the court has adjourned the matter because now the question is, if you look at purely at the statute said, the pregnancy can be terminated at any stage, provided there is an abnormality to the fetus. Here, nothing of that that sort has come as far as records what it appeared from the court proceedings today.
Okay.
So therefore, it is a delicate question. Okay. It is a delicate question, and that is where the court has asked the concerned woman that if you allow, anyway, if you do not want the child, if you do not want the pregnancy to continue, would you like to continue for another couple of more weeks to allow the fetus to grow in a healthy form and then take, do the proper delivery?
Okay. Anivesh, Madhukar, come in here. The Supreme Court asked the question that Ms. Ojha is putting to us, to the woman, and the Supreme Court today was told that the woman is going through depression. She's not in the right physical state of mind or the mental state of mind to carry the child. So there is not just depression that is involved, there is not just a mental condition that is involved, there is also a physical condition that is involved, which is why she doesn't want to carry the baby forward. Now, this is her body, her autonomy, her choice has to come first, right? If she doesn't want the child, she doesn't want to carry the child, who can stop her? Why should anyone stop her?
See, there is, in my mind, there cannot be a straitjacket formula or an answer to this. A very delicate question. Which one will prevail it would completely depend on the facts of the case and the context. So if the mother suddenly after 24 weeks decides that she doesn't want the child, it can't obviously be permitted. But if there is a fetal abnormality or there is a grave injury to her mental health as provided for in the Act, and a doctor says to that effect that this can lead to, because otherwise in the Act there are two explanations also. The first explanation, up to 20 weeks, it says for the purposes of Clause A, where any pregnancy occurs as a result of failure of any device or method used by any woman or a partner for the purpose of limiting the number of children or preventing pregnancy, the anguish caused by such pregnancy may be presumed to constitute a grave injury to the mental health. So the mental health also, otherwise the law, the Act has taken care of. What is the degree and when can it be applied? So after 24 weeks, if the fetus is normal, and only because the mother wants to abort it, to my mind that may actually set a bad precedent. But overall facts of the case would ultimately decide, because there is no right answer to this. Either way, one cannot prevail over the others.
Why do you think it will set a bad precedent?
It has to be understood in the context of the case.
Why do you say it will set a bad precedent?
No, because see, there is a postpartum depression. It would amount to, I have a baby now and I'm depressed and I'm suicidal and sometimes I want to put my child to injury, and I may be permitted to do that because it is my child. It can't be so, right? I mean, it is equating to that. So, I mean, it is a known fact that people suffer from postpartum depression, and sometimes the thoughts and feelings and emotions could be to harm the child. But if you ask a court to permit me to do so because I'm feeling that in my head, I don't think that is right. You can't do that. So if you were not planning to have a child up to 20 weeks, you are permitted to do so. Yes. Sorry.
Okay, but Madhukar, fact also is, and I'm going to get Talish Ray into this discussion as well. Fact also is, her husband was asked this. Yeah, I can hear you. Her husband was also asked the same question by the court because the court wanted to hear from the husband. The husband too said that he doesn't want the baby. There are already 2 children. There are not just these mental health and physical health issues. There is also an issue of finances. They already have 2 children. They don't want a third one. So should the family not be allowed to decide? The husband doesn't want the child. The wife doesn't want the child. How are courts allowed to, and why are courts allowed to say otherwise? But Talish Ray, the other side of the argument is
experience.
We are constantly calling this a fetus.
Sorry,
give me a minute. Let me get in Talish as well. Okay. Yeah. Go ahead.
So, out of my personal experience, we got an order for a 33 weeks fetus to be terminated, and the father of the fetus, the child, had told me earlier, the fetus was abnormal, mind you. And the father said, and then also this question, he was being constantly told that you'll be murdering a child, etc., and the child will be born alive and you will be putting the child to death, etc. And the father was taken aback, the mother was taken aback, and they were saying that we don't want to kill. And the father said that if I lift my child, no matter what the abnormality is, and they were from very poor strata of the society, they did not have the means to take care medically, financially, etc. But nevertheless, the father said, if I lift my child and hold my child, no matter what, to what my capacity is, I will fight for his life. And they got an order, but I believe they did not terminate the pregnancy because they delivered a live fetus, and we didn't have the courage to ask the father or the mother what happened after that. But I believe they went ahead with it. So
Okay.
it changes a lot. Once you lift the child that is yours, the dynamics change.
Okay, that is a choice they made. This is a choice this couple is making. All choices will be different. But Talishre,
Yes.
the Supreme Court is in a dilemma, and why this is a tough question is because the AIMS report that has come out says that the fetus has a heartbeat. It is a strong fetus. So this fetus is not just, we can't just call it a fetus. It is now a baby, an unborn child. And if the Supreme Court gives the go-ahead to terminate this pregnancy, it is giving the go-ahead to foeticide, to murdering an unborn child. How can any court in the world give permission for that? Which is why this is the dilemma. There's a mother's choice, and then the Supreme Court has to decide who is speaking on behalf of this unborn child. No one, right?
Thing here, because in terms of the complications, if one is to look at it, it's not just about a heartbeat. A heartbeat comes at around 11 weeks, it can already be felt, right? It's not only about that. There are, when we look at the laws that have come about, and in that sense, India does, as you mentioned, take a lead in the developing economies, liberal democracies, because we don't have a moment where Roe versus Wade has been reversed after many, many years, as it took place in the US. We are very firmly pro-choice. And I think that's where in terms of the facts of the case that as it has emerged at the moment, is that I think the courts are in the dilemma, but would like to help the parties also make an informed choice. You see, there is that element of, and they have to constantly, courts have been balancing, and their lordships in their wisdom have balanced the right of women's autonomy versus those rights that are given, because where a fetus is concerned beyond a particular point in time, what has been done is that various moral obligations across the world in cultures has often been used to impinge upon the women's autonomy. Bodily autonomy, by saying that, you know, this is a fetus, this fetus, when you're aborting a fetus, you're considering feticide. And if you look at the non-choice, anti-choice people, they often come up with terminologies such as murder and other things. But eventually, in this case, I think the courts are likely to balance and help them make an informed decision, because when we start looking at moral obligations versus legal rights, it does get much more complicated, much more nuanced. And I hope that tomorrow, when their lordships in their wisdom consider the issue, they will keep in mind that it is not just about what will happen to a number of litigation that will come up, merely because a greater number of litigants might plead before their lordships for their wisdom, does not mean that one is not important. Whether that one is the mother or whether that one is the child is the question that they will have to weigh tomorrow. And it is a complicated question. There is no doubt about it. There is no one who can stand up and say 26 weeks, yes, go ahead with it, without their moral conscience being invoked. And those are the kind of questions, those are the kind of dilemmas that the fraternity, which is both the bar as well as the bench, constantly face, because there are these nuanced things about looking at rights. Because if you look at what the right develops of an unborn fetus, at what point does it develop? Because it's not a natural person, but it is a person with certain rights that have been guaranteed that are there. And for me personally, I find that I do not envy any of their lordships or the wisdom that they will put behind that, But at the same time, it remains a heart-wrenching decision
Okay.
either way, because there is a mother who has said, and no, postpartum is not something that a woman can help. We need to recognize that. And I think there is time that we recognize that postpartum sometimes can be much worse than a mental health illness. And it may not be temporary. There are women who have committed suicide, who killed children, as my learned colleagues have pointed out. But at the same time, when we start talking about postpartum in terms of, we are thinking of it in terms of a temporary phase. There have been instances where postpartums have continued for very long. And we need to understand that where the medical fraternity is concerned, a lot of the research is mostly around ignoring women's health. Women's health is non-priority, and therefore sometimes the research is not very developed. And I hope tomorrow, when their lordships are considering the question, they will also consider the question that as such we take a lead where laws are concerned for the safety of women, for the choices of women. They have constantly pushed back, not just the state, but at every point in time. And that would be my appeal, that they keep in mind that this is a moment where a lot of the world will watch to see whether India truly is pro-choice or not.
Yes. So here's the thing, we can't second guess what the court does or say tomorrow. 10:30 a.m. is when the Supreme Court bench reconvenes. It is being led by the Chief Justice of India. Whichever way the Supreme Court decides, it will be a landmark judgment. Sunita, I have 20 seconds. I'm at the end of the show. Time is up, but in case you want to make a comment, I have 20 seconds.
If you look at the law as it exists today, it gives the power to the medical board to take a decision post 24 weeks, and also the method in which the termination is carried out. So what I find curious in this case, which actually led to the diversion of views by two honorable judges, and then finally constitution law, AIMS gives one report one day, and then they change. They throw back the ball in the court. If you look at the way the statute is, it is the board which has to decide how the termination has to be carried out. Now, that is something which I find a little intriguing. Yeah, and also we would be looking at what the court, the way that the decision goes. Apart from that, because under the law, it is the board which is empowered. They can take the decision, and that is how the manner in which the board is constituted. You have a gynecologist, you have a pediatrician, you have a radiologist, all that, and they have to, even with respect to the method. So when they use the term foeticide, I think that is what has taken everybody by sort of, a shock.
But many people will argue, what other word do you use? If it happens, it will be a foeticide. We'll leave it there for the moment. We'll see what the Supreme Court does and says tomorrow. It's a story we are keeping track of here on Mirana, because as I said, whichever way the Supreme Court rules, it will be a landmark judgment. Talishrey, thank you very much. Sunita Ojha, good to have you on the show. And Anvesh Madhukar, thank you very much as well. On that note, I'm slipping into a very quick break on the